I think the video is on.
First up, I have Ms. Nelson.
Yes, Your Honor.
Good morning. How can I help you?
I'm here, Your Honor. I was scheduled, I was told to Zoom in to reschedule an exam for Friday for James Pounds.
Who told you that?
I received an email from Ms. Reynolds.
Okay. Oh, okay. But Friday. Gotcha. Okay. What time were you scheduled Friday?
10:15 a.m.
Are you available later in the afternoon?
I do have an evidentiary hearing at 1:30, so as long as it's before that.
Okay. How about 11:30?
Okay.
Okay, let me call that case, okay?
Calling case number 24-56423, the people of the state of Michigan versus James Edward Pounds Jr. The defendant is charged with count 1, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, domestic violence. Today is the day and time set for a hearing.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Sophia Nelson, Neighborhood Defender Service, on behalf of Mr. Pounds, P77960. I'd waive Mr. Pounds' presence for the purposes of this hearing.
All right, and thank you, Ms. Nelson, for accommodating the court. I need to change that time. This preliminary examination was originally scheduled. Was it 10:15?
Yes, Your Honor.
Okay. What time is your other hearing that you say you have, an evidentiary hearing?
1:30.
Can you do 12 o'clock on April 12th?
I can, but if I really would have to leave at 1:15.
That's understood. I'll get you out of here, so long as your time.
I will be on time. Your Honor, I would note that you did sign a discovery order in this case. I still don't have any digital discovery. So
Train?
I'm working on getting that.
Okay.
all right, thank you, Your Honor.
Mr. Brown. Good morning, Judge. Good morning, sir. How you doing? Mr. Brown.
Yes, Judge.
Good morning, sir. What can I do for you?
Here on Malik Renfro.
Okay, we're ready on the Renfro.
Calling case number 2456503. The people of the state of Michigan versus Malik Deshaun Renfro. The defendant is charged with count 1, weapons carrying concealed, count 2, assault with a dangerous weapon, felonious assault, count 3, weapons felony firearm. Today's the day and time set for powerful vote.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Like Mr. Brown froze on.
And Your Honor, if I may, this is the case where we do have a Cody, that being Tandiona Yates.
That's one.
Okay, we have your appearance, Mr. Banter.
Richard Banter, 39845. Yes.
All right.
Okay.
As soon as I get Mr. Brown back. Yeah.
I can find it. Calling case number 2456503. Defendant 1, the people of the state of Michigan versus Tianda Yates. The defendant is charged with count 1, weapons carrying concealed, count 2, assault with a dangerous weapon, felonious assault, count 3, weapons felony firearm, count 4, domestic violence. Today's the daytime set for public vote.
Your appearance, Mr. Banter.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Again, Your Honor, Richard Banter, P 39845 for the defendant, Tianda Yates.
All right, and what's your pleasure, counsel?
Right now, we'll set it for a preliminary exam. I think they have it scheduled for next week.
Mr. Brown must be having some technical difficulty. So I'll set this for a tentative date. How's April 15th at 10 o'clock?
$15 is fine.
Okay, Mr. Brown is coming in now, and make sure that's the date. Mr. Brown,
Sorry about that, Your Honor. My device powered off for some reason by itself.
are you demanding an exam?
Yes, we are, Your Honor, and I'm also requesting this matter.
I'm sorry, you're breaking up. Try it again.
Yes, we are, Your Honor, and I'm also requesting discovery on this matter.
Okay. How's April 15th at 10 o'clock?
I have an exam in Allen Park at 9 a.m., which they might make me walk around for a little bit. If we could have it possibly closer towards noon on the 15th, I can make it.
Mr. Banter, how's April 15th at 11?
That's good, Your Honor.
11, Mr. Brown?
Yes, that'd be a good time, Your Honor.
All right, April 15th at 11 o'clock. Will be continued.
Thank you.
Do I need to weigh my client's experience?
I thought you did, I'm sorry.
I did.
All right.
I have another case up.
Who's your?
Tellis. He's here, I see him up there.
Calling case number 2456472. The people of the state of Michigan versus Andreas Allen Samuel Tellis. The defendant is charged with count 1, unlawful imprisonment, count 2, assault with a dangerous weapon, felonious assault, count 3, controlled substances possession, count 4, weapons felony firearm, count 5, weapons, felony, firearm, count 6, domestic violence, aggravated. Today's the day and time set for a probable cause.
Appearances for the record, please.
Good morning, APA Larry King for the people, P 78774.
Good morning, Your Honor. Richard Banta on behalf of the defendant Andreas Tellis, P 39845.
Mr. Tellis, tell us your name for the record.
Andres Allen Tellis.
What's your pleasure, Mr. Benson?
Your Honor, there is another case that's scheduled for the 16th for a, no, that's this case, hold on. It's for the 18th, he has another case up in 36th District Court.
What's that
Judge
case?
Giles. I don't know.
Judge Giles?
Yeah.
Okay, so my docket is a special docket, so that case will stay with Judge Giles.
So we'll have two different, that's fine. I asked that it be set for a preliminary exam.
All right, the court will continue to plead not guilty. We'll set this matter for preliminary exam. House April 15th at 10:45.
That's fine, Your Honor.
I'm sorry, Judge, what was that time again?
10:45.
Works for the people, Judge.
Bond, we continue. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Ms. Walrad.
Good morning, Your Honor. I had initially followed what the docket said and appeared in Judge Giles's courtroom, and his clerk figured out that our file is marked DV, so I'm here with Mr. Christopher Black from the Wayne County Jail.
Okay. Bring on Black.
Calling case number 2456483, the people of the state of Michigan versus Christopher DeVille Black. The defendant is charged with count 1, assault with a dangerous weapon, felony assault, habitual offender, fourth offense notice. Also calling case number 2456476, the people of the state of Michigan versus Christopher Black. The defendant is charged with count 1, assault with a dangerous weapon, felony assault. Count 2, malicious destruction of personal property, $200 or more, but less than $1,000. Count 3, domestic violence. Today is the day and time set for proper cause.
Appearances for the record, please. Ms. Grant, you're on mute.
I apologize. Good morning, Shelley Drain for the people, P number 60249.
And good morning, Veronica Walrad on behalf of Mr. Christopher Black, P85665. Mr. Black, could you please state your name for the record?
Christopher Black.
Thank you.
What's your pleasure, Ms. Walrad?
Your Honor, we're asking if this could be set for a preliminary exam date. If there are still times available on the 15th, that would be great.
Okay, let's do April 15th at 10:30.
Okay. Thank you, Your Honor. And then if we would be permitted to briefly address bond as well.
Okay.
Okay, so since the bond redetermination hearing, we have learned, both myself and Mr. Black through his family, that the complainant has successfully taken a PPO out against Mr. Black and then has expressed to his family that in light of the PPO, she is no longer scared of him and is assured that he will not attempt to make contact. His bonds in these cases are currently set at $100,000 and $50,000 cash tether respectively. And I would ask if the court would consider lowering those either into an affordable range or amending them to personal recognizance bonds still with a GPS tether in light of the fact that the complainant herself has expressed that there is an additional layer of assurance that she has that she did not have at the time of the arraignment or the bond redetermination hearing, and that Mr. Black is aware of, which would mean that he could be arrested immediately upon any violation of a no contact order.
Ms. Green? Ms. Drain?
Your Honor, I would ask for a DSU report first. There was already a bond redetermination hearing, and I don't see anything that has changed other than the complainant has gotten a PPO, which is very similar to a no contact order that was already in place. So that's what I would request.
All right, I'm inclined to go with that. I'll refer to pretrial services for bond recommendation. Bond will be continued. Thank you.
Thank you, Your Honor.
Thank you.
You're all set, Mr. Black. Mr. Moore, we're just waiting on your attorney.
Missionary and present.
I'm speaking at a few.
Oh, okay. Oh,
Yeah, that's why I'm moving some things around. Right.
I'm good. Perfect time to remember.
Yeah.
Well, I had asked for that day off. So she should have.
Mr. McAlpine.
Yes, good morning, Judge.
Good morning, sir. Are you here on Antoine Moore?
No, Malik Renfro.
Mr. Renfro?
Yeah, I went on Odyssey and it has it under NDS, but they sent me the assignment.
I think Mr. Renfro may have retained Mr. Brown.
Oh, Mr. Brown,
He appeared this morning on.
he did. Okay. Who was the other gentleman, Judge?
Yeah, I'm waiting on an attorney for a Mr. Antoine Terrell Moore.
No, I'm not on more. Okay. All right, then I guess I'm all set.
Yes, sir. Have a great day.
All right, you do the same. Take care. Bye.
Antoine Moore. Yeah. Yeah. Damien Cash. Okay.
Oh, that's the attorney? Okay,
Yeah.
I didn't know that. Here it is. Mr. Cash.
Good morning over there.
Good morning, sir. I didn't know that you were an attorney. You just said your name, Damien Cash, up there. I'm not familiar with you.
Oh, I'm sorry. I thought when I logged in on my Zoom account, it put over how I typically have it set up. So sorry, my apologies for that.
All right, you're here for Mr. Antoine Moore?
That's correct, yes.
Okay, we're ready on Antoine.
Calling case number 2255736. The people of the state of Michigan versus Antoine Terrell Moore. The defendant is charged with count 1, home invasion, 2nd degree. Count 2, arson, preparation to burn real property. Count 3, telecommunication services malicious use. Count 4, telecommunication services malicious use. Habitual offender, 4th offense notice. Today is the date and time set for probable cause.
Appearances for the record, please. Is that you, Ms. Drain?
I don't think so. I didn't hear that there was a DV charge and I didn't see this on the docket. Antoine Moore, okay. I'm sorry, I will look it up right now.
It says Lawrence King.
Larry Kings.
Lawrence.
Oh, okay, I will try to find him. One moment.
Yeah. Okay. 8737.
I'll just stand in on this one.
Okay, your appearance for the record.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And good morning, Mayor Police Court, Your Honor, Attorney Damien Cash, P number 85852 on behalf of Mr. Antoine Moore. Mr. Moore, please unmute if you're muted and state your name for the record.
Antoine Moore.
Thank you, sir.
What's the pleasure, counsel?
Now,
What's your
this time,
pleasure, counsel?
sorry, I couldn't hear that. All right. If we can adjourn for one more piece, it looks like we have a couple things confused. On my appointment sheet, all of his contact information was incorrect. As we saw each other in the other courtroom, and he reached out to me. We had a brief conversation. We just need a little time, I think, to kind of clear some things up. So if we can reset for one additional PC, a brief one, if we can do a week or so, to kind of get things aligned.
Not exactly sure what you're referring to in terms of getting things in line.
Well, I need time to be able to talk to him. I haven't had a chance to talk to him because his contact information was incorrect on my form.
Is there a possibility this may resolve itself short of an exam?
I believe so. In my brief conversation with him, I believe so.
All right. And I will adjourn the probable cause conference to, I can do Thursday, April 11th.
One second. Just took in my calendar. 8:30, April 11th. That works perfectly fine, Your Honor. We can have that date.
All right, April 11th at 8:30, bound to be continued.
Will it continue to be on Zoom for this PCC?
Yes, sir.
Okay. And I got one additional question. Ms. Drain, can I have your email address or contact information if you'll be on this case?
It is sdrain@waynecounty.com.
All right, thank you. Thank you, ma'am.
Thank you.
Ms. Moore, I believe you can log off now, and I'll get in contact with you.
Okay.
Yes. She used to always have me share annual birthday party. Oh, okay. Since she was sick, we went out and everything, she was just sick. Oh. I know.
Yes, ma'am. Yes, ma'am.
I'm surprised it wasn't on the news.
Morning, Ms. White.
Good morning. How are you, Your Honor?
I'm good. Thank you so much for coming on, okay?
Oh, no problem at all. You just needed to move the time?
Yeah, what time did I have you scheduled for originally?
I think it was originally scheduled for 10 o'clock.
Okay, yes, I need to push that back. Can I push it back to like 12:30?
Okay, 12:30. Let me just double check really quickly. Let's see. On the 12th. Yes, I could do 12:30. Absolutely.
Okay, let me go on the record with it real quick.
Calling case
Okay.
number 56212. The people of the state of Michigan versus Ricky Lewis Bushy. The defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence aggravated. Today's the day and time set for a hearing.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Coral Watt appearing on behalf of Ricky Bushy, P 41508.
All right, thank you for coming on, Ms. White. I have to attend a funeral on Friday, and so I want to push the time back to April 12th at 12 o'clock. That's the date and time.
Yes, Your Honor.
Thank you very much. I appreciate that. Bond will be continued.
Thank you, Your Honor. Have a good day, everyone.
Thank you, you too.
Thank you. Thank you.
Okay. Which gang?
Sorry.
Which gang? First name?
Deontay. Irving.
Attorney. Brian.
I think it's Brian Gag.
Brian.
Yeah. Yeah.
There he is. Mr. Gagnon, good morning.
Good morning, everyone. I am responding jumping to, I think we have to move a date for someone.
Yes, if I can just move the time back, that'd be perfect.
Whatever.
Prosecute on that.
CSC in the fourth degree, I'm not sure.
Say it's, Elizabeth Ellen.
Could be. You were set for 10, what time is the court looking at?
I'm hoping to do it maybe at 1:30.
It's got to be done before.
If I can find some more.
Can we give her a call?
Yes.
Your Honor, would it make a difference in anything if this was a possible waiver, if that's even something prosecution would allow to happen?
Sure.
Yes, that'd be what I'd be looking for. I just haven't talked.
Your client, you know.
He's gonna remain in. He does have one other case, but he just doesn't have the means to get out,
So maybe we can schedule it for tomorrow.
Yeah, we're off the record. I believe that anything that I want to handle that involves his mental health, I'm going to handle it at Frank Murphy. I believe that I would be able to wait tomorrow at everyone's school.
Okay, so we'll get them out for tomorrow.
That'd be fine. You want me physically down here?
Oh. Yes.
Oh, yeah, that'd be perfect.
Okay. All right. Thank you.
Thank you.
Appreciate it. So we're going to do Hartville for the hearings tomorrow. Yes. Yeah. Or you just leave this here. That's it.
Yeah.
I know. Trying to make it happen today. I just got my social security card back from the mail. Going down later. Well, now. All the time.
What's up, man?
Okay.
Oh, man, sure.
Yes, we have probably goes there.
11 o'clock. Yeah. 11 o'clock.
Okay. Okay.
What's up, Chair?
Hi.
All right, how you doing?
Yeah, how you doing?
What's up? Busy. 30.
It's a breeze for this. I just got here. Got a tip from single people. No, they still want to. Jefferson still.
Mike. Get down. He was at your church?
Yeah.
For his church?
It was a 3 o'clock service.
You want full service?
I can't go. I do listen to this God. I have everything like stream stuff. Michelle.
Who?
Michelle.
No, I heard she passed away or something.
All right, so if I get.
Okay, Chair.
Mr. Gagnon's case. Mr. Gagnon at 8:35.
Yeah, so we didn't put it on record, but he was one to put it over for a hearing tomorrow at 8:30 for a possible waiver.
Okay, what about Nelson? Mr. Nelson, Pounds.
So that one, the exam is going to be at 12 on 4/12.
Thank you.
You're welcome.
So we just wait on that.
No, yeah.
There's another prospect. They all over the place. Mr. Taylor.
Yes, sir.
So there's another prospect over there. They all over the place.
Oh, yes, sir. Yes, sir. Holding it down.
It's warm in here.
That's so nice outside. Supposed to be 74. Yeah. I work Velveteen. Yes, I'll get that.
You too.
Thank you. Morning.
I would do this, and it would let me go to the area. You like, let me out, being live, and then, yeah, update, and I'm just started running that. Never. She Oh, yeah. Maybe I take up. They, but I ain't what? They feel like a good. I went to 2 places down there. Hey, like I didn't know, I didn't want to do something. I didn't know that you made it. Oh, you can make. I went again. Like I was the other day. After that, at like 6 o'clock. Okay. Like. I mean, I went last. I tried to last week. You like. You just like. I wait like 20 minutes. Yeah, yeah. And, I like my. You said that. You did say that. And I like myself. Okay. I think they was good, but it just, it was the way it's mentioned, it was too long. And they, I don't know. They were, when I was like, dang, I'm not gonna make it. These are the bus. These are the bus. First day I like, oh, tired. I'm like, these people so ghetto. I went downstairs to check and I kept checking the stove on. Oh, I want. Look, yeah. I kind of want to. I don't want to. Because I got salt. I got the weekend from last week. No, I had chicken. The real, so I got cool mystery. Oh, I hate that. And I can't eat it myself. So I mix them. I Cheetos. And then I can eat it. But once I cheat, I can't eat it. Right. You don't like those? It's over there. I didn't write this high. This yours? Oh, that's yours. Oh, no, I didn't know. Okay. Where did you get that from? Girl, 5. They was in there? My determination. Oh, okay. Okay. You know, she left it on my desk. Right. Going, Miss Madison, I'm not just sitting on the computer and moving to report. I don't know about this one, but it's like, I guess it's not on network or something. I don't know. It's not working. Well, at first, no, not really. No, at first, the Zoom, I like clicked on video logging out of JIS. Then it told me that my email was updated. And then, I tried to, nothing is working. Okay. Mhm. Okay. Yeah, yeah, I can see that right now. It looks like a little Wi-Fi box. Yeah, the lights, I don't see no lights on them. I don't think they will. Yeah. Okay, I just plugged it back in. It will say my fingers out. So now the lights on. Mhm. Okay. 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 The email saying they stuck today, but all my icons are not there. My icons are not. Okay. Okay, that's good, because even JIS and stuff. Okay, cool. I think that was it. I'm gonna try to log back into JIS. Okay, thank you. For a year. I just got my 1 year on April 3rd. Thank you.
You like it?
Yeah, that's good.
For the private.
I was the cashier on one.
Okay.
And then before that, I was, in the back on one. In case negotiation, we like tickets and, prepping the files, prepping these files, so telling the arraignments and stuff.
Okay.
Yeah, did that for like 3 years, and I was the, cashier for about a year. And I come up here.
Okay. So switch position like this.
I like this position, probably like the next, but they all okay, like cashier was cool, but after a while I got bored, like, it's the same thing. So I like to do different stuff, and keep trying on something new, but like, I'm up here, so it's like different documents, like the traffic document, family document, so I like that part of it. Not just the same thing every day, I get bored with it.
I can see how this would be.
Yeah.
That's
Yeah, cause I might be doing traffic tomorrow or small claims or civil, so, you know, it's a little different.
Would you want to decide to one judge or simply not?
I don't know. I haven't thought about that yet, because I'm just a floating person, I have my time, but I don't know, I think I might like the floating.
I was gonna say.
You know, to try to do something different, but I really don't know.
Yeah, because you would have to have that type of personality, who's flexible, you know, willing to change, you know,
Yeah.
the win. But if you like just, you know, to know what to expect.
Right, a set schedule is you have to go ahead and stay there.
Yeah.
Thank you. Are you assigned to a judge?
Judge Taylor.
Okay.
She's on track.
Okay, yeah, okay, well, Mary.
Yeah.
Just helping out in here today.
Well, with, the court reporters rotate.
Okay.
You know, week at a time.
Okay.
To take the place of the judge that's assigned to him. So even though this is not my week to rotate, another reporter asked to take this week.
Okay, yeah.
I'm helping her out. What's your last name?
Ramsey.
Ramsey. You have a relative named Billy who might have been a court reporter?
Not that I know of.
Okay. Okay, Ramsey, her name is Billy. She's
Really?
the judge of Bright.
Okay.
She's retired. I look like it now that I look at
Really?
face.
Yeah, I haven't heard of a family member named Billy, but
you said what?
I heard of a family member named Billy, but I wouldn't put it past. It's a small world.
Are you from the east side?
No, the west side.
Okay, she lives on the east side.
Okay. That's cool. How do you like being a court reporter?
Good job. I love it.
Okay.
But I'm ready to retire. 2 more years, it'll be 50 years.
Wow.
So
Okay.
this is not 50, 48 years.
Okay. Okay.
Yes,
I know, you like, yeah, it's cool, but you like, I'm tired, yeah. Okay.
But I don't want to just retire, just to say I'm retired. You know? I still love doing what I'm doing. I'm in good, you know, enough health, thank God, where it's not a problem to do it. So I'm like,
you know, why not? Yeah.
Why not? Yeah. I don't get paid for doing something that I love.
That you actually like, yeah.
Yeah, but my husband just retired last year, this April, no, this May 1st is his first year being retired.
Okay, okay.
So it's kind of getting to me when I gotta get up.
Mm-hmm.
And go to work. You know. See you later.
See you later.
But, you know, it hasn't like interfered with anything that I want to do with him or anything, so. I don't know when I'm
Right. Can you be like part-time?
I could, but I'm like, I have that stable, steady personality, like opposite of yours. You know, like if I were in the pool, you know, what judge I'm assigned to, you know, I would probably rather be assigned to.
Okay.
But judge I'm assigned to was very nice. I enjoyed working with her.
I met her not too long ago. She is nice.
And if I wasn't assigned to a judge, you know, I don't know where I'm gonna be that day. You know, saying to go to get this, saying to go that place. I don't like that.
Yeah. Yeah, what do you want to know? Like, what's going on?
Yeah, and you get assigned to a judge. Don't have this. He's cool.
Yeah.
Very even tempered. Nothing personal.
Yeah. Light docket today too. I said light docket today too. Okay.
So if you need my attention, you know, just wait.
Okay.
I'm gonna need these headphones.
Oh, yeah, no, I know, okay. Mhm.
Just to give me a second, 48 years.
That's a long time, you say I'm tired. Mhm.
And that's what my Smith numbers,
Right, right,
it too.
right.
Matter of fact, I got my number when they first started passing them out.
Oh, wow, okay.
You ain't got no goodies for us to eat on?
No, I ain't got no, I just found some chips right here, I ate chip, I want some more snacks.
Yeah, like you ain't bring us no goodies.
Mhm.
Good days, one.
Yeah,
It's nice as I don't know what I'm saying.
already,
I'm just
it was
saying,
decent this morning.
I just came from out there. It's so,
Okay.
it's so beautiful. It's like, oh my God, it's lovely. Can't wait till this last case over.
I know, right?
I'm telling you.
Right now, it's so hard.
Yeah, you're right.
how you doing? Jerry, I can just call one and Madison talking about the issue, but, I was calling to see if you can, you know, whatever an attorney of, her, okay. They was on Zoom this morning and, I didn't catch that. Okay. And I can give you the date number for you. Ryan, yeah. Okay. Okay, thank you. I gotta move around. Right, so it might take a house, maybe, so okay.
Straight chilling, huh? Doing all your input work, huh?
Go back outside?
Yeah, oh my
It's
God.
still fine.
That's an understatement.
Really?
See, I can't do that. If I go out, I'm going on.
You be like, I wanna go.
I didn't go no further to the front. I just went to the front door.
Yeah, you be wanting to not come back.
Yeah, well, it won't be long.
I know, right?
It won't be long. Hey, LT, how you doing? I'm good. I'm up in good. Kings, can we get Medley? But we don't, in about, maybe about 5 minutes, if that's okay. Okay, thanks, Lou. Okay, yeah.
Manly, custody.
Yeah. Say your name, Madison, huh?
Yeah.
I got a niece named Madison. Two of them, actually. Two of them. Yeah.
Okay.
That's his name. They were pretty good. They were pretty too.
Oh, really? How are
One is about 16.
Okay.
And the other one is about 11.
Okay.
Yeah.
How they spell it? The regular way?
You got me. You got me. I would assume it's like Madison, Wisconsin.
Mm-hmm. Cause I spell my name.
You spell it with a Y?
Yeah.
Oh, yeah?
MAVISYN.
Okay.
Instead of
Yeah, that's cool. Man, I'm so ready to go.
Mm-hmm.
It's so nice out there. Oh, God.
It's straight for now, but I said 38, let's see what you say now. Said 67. It's crazy because I was gonna work some sandwich today. I'm like, no, it's a little too chilly, but I could.
You could have got away with it once you left out of here.
Right. Yes, man. Really, you right in? Yeah, I think you're gonna wait time.
Yeah, that's sweet.
Five for CMA. Over on Renfro, well, like Grand River, Renfro,
That's the question.
they think it is now.
I mean, you know, higher education, like some of the smart kids go for it, right?
I mean, I don't know, I think it's just it's school of choice, that's what they call it. But, you know, it's supposed to be like communication, media, art, so, but we ain't do none of that.
Oh, no?
No, we had got our school redone, and they gave us like a media center. We ain't go in there and do nothing, all we do is go in there and take our ID pictures. We ain't do nothing they got to do with it, none of that.
Big dog, we trying to get this last one over with, man.
What the people say? You check in yet?
Nah, it's some people, I got the complainant in the room.
Oh, no.
I didn't get his name, but his attorney out there.
So this attorney's here?
Yeah, I put him in this room, man.
What about the prosecutor?
I ain't seen no prosecutor.
Check.
They holding that thing,
Huh?
they holding that thing.
Oh, they got to. It's
Okay.
homicide. They can't move away now.
Okay. Yeah, I did, I ran track for a minute, like, I was cheer when I was younger, not high school. But, yeah, I'm a cheer coach now.
Oh, yeah?
Mhm.
It's
I'm
good.
a cheer coach for like, since 22.
I see me.
Nah, the little league,
Huh?
like the little Cali stuff.
Oh, you must got a daughter this year.
I gotta be.
What?
Yeah, I thought it was coaching in 2020, so this is my 2020. Or 4th year coaching.
Oh, wow, that's good.
Yeah.
Because I know it's volunteer, I know that.
Yeah, and it's a lot.
That's why I ain't coaching basketball.
Yeah, because it's very time consuming.
Plus, basketball, look, different. Parents think their kids is the best, so he's supposed to play and probably can't play. I'm not gonna be arguing with my parent about the kid.
And that's why I don't want to be head coach, because I don't want to deal with our parents directly. Because they, now I get it, you don't play about that kid, but they do too much.
Yeah, yeah.
I'll be assistant coach, I don't want to be head coach, I don't want to deal with our parents directly. I will speak to some people, but when we can be the first contact, no, I don't want to do that.
I used to be a referee too.
Okay.
But I quit refereeing because, you can't talk to me and say anything to me that you feel because I'm getting $55 for this 1 hour.
Right. We ain't about to do that.
We ain't about to be disrespectful. I don't tolerate disrespect.
Hey.
Oh, man, are you telling me?
That's what he just keeps saying.
Oh, my God.
I can't wait for that.
Make sure my legs are back.
I heard that. Hey, if this go, Tyler gonna come get it. I mean, it's gonna go, but it's gonna be, beyond the time I need to make a move. You got siblings?
No.
Your only child?
I actually have a lot of long sister. I found her years ago. But we ain't really never. I grew up by myself. Yeah, I talk to her sometimes. I haven't talked to her in a while. Got a long sister.
Christmas, so we ready to rock and roll.
Anybody hear that?
Yes, sir, the prosecutor and his main witness, I'll get the prisoner up.
No defense counsel yet?
They looked at the game last night.
They wear you down, man.
Yeah.
They wear you down.
I'm like a championship experience.
Yeah, that's it. Well, Purdue wasn't championship caliber team. He was just bigger than everybody.
That's all.
You know.
Be a rude awakening in the NBA.
He ain't
gonna be bigger than everybody there.
Exactly. And he not gonna
Or
be
stronger.
He's not even gonna be picked in the top 10.
He was winded too. He was tired.
Yeah, see, last night he finally had some guys his size. Cause UConn had 7'2", 7'3" guys too.
Yeah. He was still bigger than them.
Yeah, he's a big boy. You know, we could do with him as a Piston, though. We don't need him.
No. You better not draft him.
Man, I'll go crazy.
Still got a worse record in the NBA?
Yes.
Worse than us.
San Antonio come in second.
Okay.
But that don't mean we're gonna get the first pick. Which this year.
We should have guys that's in San Antonio last year.
Yeah. This year is no cut outright #1 unanimous pick. So we'll probably get it because it ain't no superstar that everybody wanna have.
Let's go. Oh, no.
When we taking people off the road the other day.
Yeah, he's a freak of nature.
Who was that?
Wembley got a 77 and play for San Antonio.
Oh,
The rookie.
yeah, he's a freak of nature. You don't find guys that tall, that graceful, what he can do.
He going in between his legs, everything.
Round the back, step back, threes.
Hey, okay, all right. I know, they're not as efficient as we are, I understand. Okay, all right. Okay. Mr. Clemens is just driving in. They're looking at 5 minutes. So it sounds good, but it's not sufficient. Let me see that 5. Thank you. Thank you.
Here, thank you. Okay.
Yes.
No. No. Yes. Calling case 2456332, people of the state of Michigan versus Jawan Rakeem Zed. Defendant is charged in count 1 homicide, murder, first degree premeditated. Count 2 felony firearm. Appearances for the.
Good morning, Your Honor. John Bell on behalf of the people, P68673.
May it please the court, Judge, my name is Adam Clemens, P number 77233, appearing on behalf of the defendant. So state your name for the record, please.
Juwan Minton. There's a date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
How many witnesses will be?
1.
And do you have any preliminary matters before you call witnesses?
Yes, Your Honor. Your Honor, we have a stipulation to the identification of the victim, in this case, Abram Houston, as well as the stipulation to the admission for preliminary exam purposes of People's Exhibit number 1, which is the medical examiner's report of Abram Houston. May I approach with Exhibit 1?
So stipulated?
Yes, as I this received.
Court receives those stipulations. Thank you, sir.
Your Honor, may I call my first witness?
Yes, please.
Your Honor, the people called to the stand, Javon Houston.
While Mr. Houston is making his way in, Judge, the defense at this time will move for visual sequestration for any potential witnesses.
Your Honor, with the exception of the OIC, nobody who's not going to testify today. The victim's mother's here, but she's also not present.
The objection to the OIC remain and a mom.
I thought Detective Poop was the OIC, if that's not the case. All right, that's fine.
All right, ladies and gentlemen in the audience, if you are a witness or potential witness, I have to ask you to step into the hallway to further notice. Also, people out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. Sir, please give your name and spelling to the young lady behind. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. Please have a seat. The witness box right next to me. Just pull that door open and have a seat. Speaking to that microphone that'll be to your left. Maybe begin when you're ready.
Thank you, Your Honor. Good morning, sir. Can I ask that you state your full name and spell it for the record?
John, Houston, H-O-U-S-T-O-N.
Thank you, Mr. Houston. Mr. Houston, I want to draw your attention to February 20th of this year, 2024. Where were you residing on that date?
Well,
Is that 13305 Wilford Street in the city of Detroit, Wayne County, state of Michigan?
yes,
And was that your home at that time?
yes.
And in the evening hours, afternoon evening hours of February 20th of this year, what was happening at your house? Birthday, cousin's birthday. Okay, who was your cousin? Rick. Okay, so you're having a birthday party at your house?
Yeah.
Approximately how many people were at your house?
15 people.
I'm sorry, how many?
Like 15 people.
Like 15 people, okay. Do you know an individual, by the name of Juwan Medley?
Yeah.
Was the person you know as Juwan Medley at your house that day?
Yeah.
Approximately what time did he arrive at your home that day?
Earlier that day, I don't remember.
When you say earlier, are we talking morning, afternoon, evening?
Afternoon.
Afternoon?
Yeah, like 2.
The person you know as Juwan Medley, you see him present in the courtroom today?
Yeah.
Can you point to him and identify what he's wearing?
Yeah, green jumpsuit.
Your Honor, may the record reflect that this is pointing to and identifying the defendant in this case, Juwan Rakeem Medley?
So noted.
And, sir, do you know an individual by the name of Abram Houston?
Yeah.
And was Abram Houston present at your house on February 20th?
Yeah.
Approximately what time did he arrive?
6 or 7.
Would that be 6 or 7 p.m. in the evening?
Yes.
Okay. And when Mr. Abram Houston arrived, was he there for the birthday party?
Yeah.
Okay. At some point, was there an altercation in your home?
Yeah.
Can you describe what led up to that altercation? Let me ask you this. At any point in your house, was there an argument between the defendant and Mr. Abram Houston?
Yeah.
Okay. Prior to that argument, or let me ask you this, do you know what that argument was about?
Yeah.
What was that argument about?
Hot dog.
When you say a hot dog, what do you mean?
Hot dog.
Why were they arguing over a hot dog?
Please speak into the microphone, sir. I can't hear you.
Everyone used to pick up John, girlfriend, hot dog, and that eat.
So you said Abraham Houston picked up the defendant's girlfriend's hot dog and began eating it?
Yes.
And that started an argument?
Yeah.
What, did you physically observe this argument?
Excuse me?
Did you see the argument?
Yeah.
What happened during the argument between the defendant and Abram Houston?
Arguing back and forth, and they pulled out guns on each other.
They were arguing back and forth. You said they pulled out guns on each other. Did each of them have a gun?
Yeah.
We'll start with the defendant. What was the defendant doing with his gun?
They just pulled them on them, like, in the ear.
Were they pointing guns at each other, or how were they pointing them?
No, they just had them on their side and they hit.
Okay.
Talking to each other, arguing with each other.
So the defendant had a gun in his hand, and you stated Mr. Abram Houston also had a gun in his hand?
Yeah.
Okay. How long did this argument last for?
Okay.
Okay. At some point, did the argument stop?
Yeah. Well, yeah.
And what, if anything, did you do during this argument?
I told them they not about to do that in here. Chill that shit out. And told everybody they got to leave.
You told everybody they had to leave?
Yeah.
Okay. And after you told everybody they had to leave, were people leaving?
Yeah.
Who was the first person to leave?
Abraham Houston.
Abraham Houston?
Yeah.
And did he leave through the front door, back door? Where did he leave? Front door. When Mr. Houston, Abraham Houston left your house through the front door, where were you staying?
On the front porch.
On the front porch?
Yeah.
Okay. When Mr. Houston left, were you able to see his hands?
Yeah.
Did he have a gun in his hands at that time?
No.
Okay. Where did Mr. Houston go?
He was like, just bottom of the stairs and grabbed.
On the grass, would that be the front lawn?
Yeah,
Okay, and was he standing in the grass?
yeah,
At the time that you saw him standing in the grass, let me rephrase that. From the time he was leaving the home, you indicate he didn't have a gun in his hand, to the time he's standing in the grass, did you ever see him with a gun in his hand again?
no,
And what, if anything, did the defendant in this case do?
ran past everybody in the shop.
Okay, we back up a little bit. When you say he ran past everybody, was this before or after Mr. Abraham Houston was standing out on the lawn? Okay, when you say the defendant ran past everyone, can you describe it for what you mean by that?
So he just ran past everybody. Everybody was going out the front door.
Okay, so people are trying to leave through the front door. Was he, when you say ran past, was he running past everybody in the house to get outside?
Yeah,
Describe what you mean by running past everybody.
like he just went around everybody.
So he went around everybody.
Yeah,
Did he leave, exit through the front door?
yeah,
Did you see if he had anything in his hands at that time?
no,
Okay.
I just, it happened so quick.
Okay. When the defendant ran outside, where did he go?
It was on the front porch.
The same front porch that you were on?
Yeah,
What, at that time, actually, from that point forward, did you ever see Mr. Abraham Houston with a gun?
no,
Did you see the defendant with a gun?
yeah.
Can you describe the gun that you saw the defendant with?
It was just a black, it was just a black gun.
Okay.
I heard the shots, you see the gun.
Okay, when you say a black gun, do you know the difference between a rifle and a handgun?
It was a man.
Okay, so a black handgun?
Yeah,
What, if anything, did you see the defendant do with that handgun when he was standing on your porch?
shoot,
Was he pointing the gun at somebody?
yeah,
Who was he pointing the gun at?
yes,
While Mr. Houston was standing on the front lawn?
yeah,
And you say he was shooting. When you say he, who were you referring to?
no,
The defendant? I'm sorry, is that a yes?
yes,
Okay, so you saw the defendant pointing a gun at Mr. Houston while Mr. Houston was on the lawn, and you saw the defendant shooting?
yeah.
How many shots did you see or hear the defendant shoot?
I heard like five shots.
5 shots?
Yeah.
Was he pointing the gun at Mr. Houston when he was shooting?
Yeah,
What, if anything, did Mr. Houston do when he was getting shot at? Just fell down to the ground? Did anybody ever, to your knowledge, remove a gun from Mr. Houston, Mr. Abraham Houston? After Mr. Houston fell to the ground, what did the defendant do? What did you do after the shooting?
I took off.
Oh, you took off and left?
Yeah.
Did you report this to the police?
No.
Okay. Did you eventually report this to the police? Did the police come to you or did you go to the police?
I went, they came to my house. I went there.
When you say you went down there, where did you go?
To headquarters or something.
Detroit Police Department headquarters?
Yeah,
Okay, so when you went down there, did you give a statement?
yeah.
Thank you, Mr. Houston. I don't have any further questions for you at this time. I believe defense counsel will.
Cross-examination? Yes, sir. Good morning to you. I'm going to ask you some questions on behalf of Mr. Medley. If I speak too fast or ask you a question you don't understand, just let me know. I'll try to ask you a better question, okay?
Okay.
In relationship to this incident, do you recall when you went to the police station to give your statement?
Yes, I think it was March 11th.
Okay. And you agree that this incident took place on February the 20th, 2024, is that correct?
Yeah.
Is that a yes?
Yes.
Okay. At any point in time, sir, on February the 20th, 2024, did you call 911? The home where this incident took place, you testified that that's your residence, correct?
Yeah.
Okay. And you also, you had an opportunity to meet with this gentleman here, did you not? And when you had an opportunity, indicated for the record that I was pointing at, he was substituting as the officer in charge proceeding in the first row, just for the record. And when you had an opportunity to meet with this gentleman, there was another detective, an African-American detective that was there as well, is that correct?
Yeah.
And there were specific questions that were asked of you and you provided answers, is that correct?
Yes.
And you'd agree with me that when you had an initial opportunity to speak to these officers, you told them that you weren't present for the altercation, is that correct?
Yes.
When they asked you specifically what happened at that location, you told them that you went to a party, that there was a party there, you were having a good time, and then you left to go pick up your daughter, correct?
Yeah.
Was that information true? So you lied to the police when you initially met with them, is that correct? In relationship to this investigation, sir, you've never been arrested for providing false information to the police, right?
No.
That, as far as you know, you haven't been charged with providing false information to the police, correct? But you'd agree, you admit that you provided false information deliberately as it relates to this investigation, right?
Yeah.
Okay. Also, the home where this location took place, there are security cameras, right?
Yeah.
You bought the security cameras, right?
Yeah.
Okay, and the security camera.
Would you please lean back a little bit, your hair is running against the microphone. Okay, would you repeat your last answer? You bought the security cameras, right?
Yeah.
Thank you.
How did those security cameras record? Do you know if they fed into a DVR?
Yeah.
What happened to the DVR?
I don't know.
So, when is the last time you had seen the DVR prior to this incident taking place? So, and then you had an opportunity, the detective specifically asked you, what happened to the DVR, right? When you, and you told him you don't know, correct?
Yeah.
Okay, but you'd agree that this is your house, right?
Yeah.
You maintain the security cameras there, correct?
You said so, yeah.
No, I'm asking you. I mean, I can't put words in your mouth. So the answer to my question is no, then no. I'm asking you. You purchased the security cameras, correct?
Yeah.
You've seen the DVR on that day, right?
Yeah.
And now that it's missing, you don't have any idea where it is, right?
No.
You didn't go to the police on February 21st and say that Jawan Medley killed Mr. Houston, correct?
Yeah.
Didn't do, on February 22nd, you didn't call the police and say that Jawan Medley killed Mr. Houston, did you?
No.
At any point in February, did you contact the police?
No.
Isn't it true that when you had an opportunity to meet with this detective in the first row and another detective, they specifically told you that you were a suspect in Mr. Houston's killing?
Yeah, I mean,
Does this go to effect on the listener? That was conveyed to you, wasn't it?
Yeah.
And it was only at that point where you were told that you were a suspect that you didn't say that Mr. Medley was the shooter, correct? Is that yes or no?
Yeah.
But in your written statement that you completed, nothing in your, you signed this written statement after you had an opportunity to finish your interview with the detectives, correct?
Yeah.
And but you agree that nowhere in your written statement is your initial position outlined where you specifically say that you left the house and didn't see an altercation at all. That's not in your written statement.
No.
Because when you started giving your written statement, you had decided that you were going to be truthful, at least tell a different version of the events, correct?
Yeah.
When you had an opportunity, sir, to observe, you claim that you observed Mr. Medley actually shoot, correct?
Yeah.
Okay. And it's your testimony that he was standing on the porch and Mr. Houston was standing on the grass, right?
Yeah.
Okay. Have you fired a gun before, sir?
Have I fired a gun?
Yes. Have you fired a gun? The gun that you said that Mr. Medley had, would it be consistent with being a semi-automatic handgun or a revolver?
Semi-automatic handgun.
You were able to see shell casings ejected from the handgun, is that correct?
No, I didn't see all
Okay. So when you say you didn't see all that, were you looking at Mr. Houston while he was being shot?
Yeah.
Were there points in times where Mr. Houston was on the ground while he was being shot, or was he standing up the entire time?
He was standing up.
Okay. And was there a particular, you testified that you didn't see anything in his hands, is that correct?
No.
Did you take the gun away from Mr. Houston?
No.
How much time elapsed between the time that you saw Mr. Houston and Mr. Medley arguing where they both had handguns and the shooting took place? Was it a matter of minutes? Was it a matter of seconds?
Right, minutes.
Okay, did you see anyone take Mr. Houston's gun from him?
No.
In fact, after you were able to separate the two, you told the police that Mr. Houston put the gun back into his pants, correct?
That's it.
Okay, so when Mr. Vela asked you whether or not you saw a gun in his hands when he was being shot, do you know whether or not he had a gun on him while he was being shot?
I didn't see nothing.
Okay. Do you have an explanation for why no handgun from Mr. Houston has been recovered? Okay, so just to clarify, you don't know what happened to Mr. Houston's handgun, correct? Correct?
Yeah.
You don't know what happened to the DVR, which would have captured the incident, right?
Yeah.
And you waited a full 3 weeks before you decided to come forward and explain to the police what happened on that particular day, correct?
Yeah.
Who else was at the house on that particular day? I can't hear you.
There was a few people.
Oh, do you know these individuals?
Yeah.
What are their names?
Me, Lana,
I'm sorry, Lana?
Asha, Reggie.
You testified that it was about 15, is that correct?
Yeah, it was 10 people.
You used the name Asha, is that correct?
Yeah.
Is that what you have an understanding of her full name to be?
Yeah, I believe, yeah.
You know, if her last name is Brown?
No, her last name not Brown.
How would you describe your relationship with the defendant?
That's my cousin.
How would you describe your relationship with Mr. Houston?
That's my cousin.
Okay, so these are individuals that, as far as you knew, also knew each other, is that correct?
Yeah.
These are individuals that were at your home, invited guests at your home on a particular evening, right?
Come there anyway.
So what I'm asking is, these are individuals that it would not be abnormal for them to be at your home, correct?
What you mean?
It's ordinary for them to come over your house and be there together, is that correct?
Yeah.
Okay. This was nothing out of the ordinary except that something tragic happened, is that fair to say?
Yeah.
Okay. On the night in question, sir, did you get into a physical altercation with anyone?
No.
I don't have anything further, Judge, thank you.
You need me direct?
No, thank you, Your Honor.
I think Mr. Clement asked you how much time lapsed between this argument and you said both men had guns, both of your cousins had guns, and they were kind of faced off with each other. How much time elapsed by the time that happened to where Mr. Houston is on the grass and you say, defendant Mr. Benton fire shots at him.
5-10 minutes.
5 or 10 minutes.
Probably so.
Did you see how the argument ended? The initial argument, they're both holding guns? Because you said you got between them, right?
Yes, that's how the argument ended.
That's how the argument ended?
Yeah, it was
When the argument ended, were they still talking to each other?
and they was saying little stuff, but yeah.
You said this was all over a hot dog.
Yes.
You live in that house by yourself?
Girls doing that.
What's your girl's name?
Bushy.
Asha was there at the time?
Yeah, she was there.
Any questions based on my question?
No, thank you, Your Honor. Yes. You just told the court that you believe there was 5 to 10 minutes that elapsed between the end of the altercation and the shooting?
Yeah, I believe so.
Okay, but you'd agree that when I asked you the same question, you said 1 minute, correct?
No, I said minutes.
Do you draw a distinction between 5 or 10 minutes and a minute or two, or is that a significant difference to you, or is it about the same?
You asked me minutes, I said minutes with S.
But what I'm asking you, sir, is 5 to 10 minutes, would you agree is a substantial amount of time?
No.
Okay. During that 5 or 10 minutes, is there any argument?
Saying stuff to each other. No.
They were saying stuff to each other, yes, but what I'm saying is that's happening for the entire time?
Yeah.
So then what I'm asking you is, this was a continuation from the original altercation that you broke up, right?
Yeah.
So there was never really a calming down point or point where it stopped. You separated them and they continued arguing. Is that your testimony?
Yeah.
The only difference is that Mr. Houston put his gun back in his pants, but they continued arguing, correct?
Yeah.
Thank you. Nothing further.
Anything else, Mr. Belly?
No, Your Honor.
Thank you, sir. You may start.
No further witnesses.
Any witnesses for the defendant?
I want to call the officer in charge of this one question. I want to ask the gentleman one question.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Thank you, sir. Please have a seat.
Sir, good afternoon to you.
Good afternoon.
What was your name, please, sir?
Sergeant Stephen Hyde.
Sergeant Hyde, in relationship to this investigation, was there ever a second firearm that was recovered from the home where this incident took place?
No, I don't believe so.
And, well, let me say this. I use the term second firearm. That's probably not a good question. Was there any firearm, as far as you know, that was recovered from the home on the night in question at all?
No.
Was there any firearm that was recovered from Mr. Houston at all?
No.
Would you agree with me that there's a .40 caliber shell casing to the immediate right of Mr. Houston's body?
I believe there was one on scene. I'm not sure exactly where it was positioned at.
And you'd agree that the firearm, from a caliber perspective, that was utilized to kill Mr. Houston is a 9mm, correct?
That is correct.
Thank you. Nothing further.
So,
Just briefly, Sergeant Hyde, do you know how long that 40 cal shell casing was there?
I have no idea.
No further.
thank you, sir. You may start.
Thank you.
Anything else, Mr. Clemens?
Oh, no, thank you.
People?
Removing from bind-over as charged to a probable cause hearing. The court heard from Mr. Javon Houston that there was an argument in the house over the victim, in this case, Abraham Houston, apparently eating the hot dog that belonged to the defendant's girlfriend. They both pulled out guns, held guns, argued. He got in between them, tried to defuse the situation. Then Mr. Houston put his, Mr. Abraham Houston put his gun back in his pocket. Then Mr. Javon Houston asked everybody to leave. He was standing on the porch. Mr. Abraham Houston was out on the grass, did not see any gun in his hand at any time after he left the home. And then it was the defendant who pushed past everybody with a gun in his hand to get around everybody to go to the porch and started shooting and did in fact shoot Mr. Abraham Houston. I certainly believe by probable cause standard that was deliberate, that he had the intent to kill. He did have enough time, although the law doesn't specify what amount of time is required for premeditation. The fact that somebody has already left the home and he has a gun and he's pushing past everybody to get to the porch to shoot that individual is certainly enough time for premeditation, as it appears from the facts in this case.
Mr. Clemens?
Yes, there's the nature of my objection to the bind-over request would be as follows. I think that when the court has an opportunity to sit in the seat as long as the court has, listen to as many pieces of testimony as the court has, to receive information from one witness, when there's 15 people that are reportedly at a party, a witness who has no explanation for how his DVR just mysteriously disappears, and a witness who by his own admission says that he only fingered Mr. Medley after he was told specifically that he was going to be potentially charged with this homicide. Only then does he say, oh no, it was Jawan. It's not lost on me. I would not be doing my job if I didn't advocate or highlight how ridiculous I think the rationale is that he provides for why he believes that this happened. He says that this was over someone eating a hot dog, that my client would just go kill someone. So I'd ask the court just to not believe that at all from a credibility perspective. You're talking about believing someone that goes in and lies to the police, admittedly, given a free pass for lying, and then only decides that he's going to tell the truth when they say, well, we're going to charge you. You can look at the physical appearance. I'd ask the court to take judicial notice. Please stand up, Mr. Medley, very quickly, if I may. If you look at his physical appearance from a hair type, from a body type, okay, you can sit down. It's not that much difference in terms of how they appear in stature. I don't know what these purported other witnesses told because I don't have any other witness statements. All we have is this testimony on this record from an admitted liar, an individual who has DVR in his home, who has cameras in his home, gives no explanation for where the DVR recordings are, says, oh yeah, Mr. Houston had a gun, but that just mysteriously disappears as well. And then there's a different caliber shell casing right next to Mr. Houston. And then what this court is supposed to do for purposes of probable cause is just say, oh, well, we'll just accept that ridiculous explanation that this killing happened over a hot dog, and we'll just assume that that's an old shell casing.
You're not saying that it couldn't happen over a hot dog. I've had people die over a slice of pizza.
Well,
Little Caesars, right?
Well, I'm saying it didn't happen just because I'm relying upon communications from Mr. Medley, and I know the court can't do that. So I'm going to argue based upon the information that I have. And I understand that the court has to make evaluations from a credibility perspective in totality, but I'm asking the court to receive the testimony as it was provided. You got an individual that's looking down, looking away, yeah, mumbling, not speaking with any confidence, and he's an admitted liar. And that's good enough to just have my client wait 8 months while he sits in jail for another trial that he'll presumably win. That's my objection to the finding. Thank you.
Do you have any objection as it relates to, I am satisfied that this was the defendant who caused the murder of Abraham Houston? First degree murder as opposed to second.
I'm asking the court to dismiss it as a whole, but if the court wants me to address that, what I would say is you have an individual that he can't give you any specificity. I asked when I asked him initially, I said, how much time between the conclusion of the argument and then when the shooting initiates? And he says minutes. And then the court pressed further, wanted a definitive answer because that's important. Then he says 5 or 10 minutes. So then when I have an opportunity on recross, I'm asking him specifically, did the argument ever stop? And he says no. So from my perspective, Judge, it's a continuation of the same event, which would not be significant, which would not be sufficient to establish a case for premeditated murder in the first degree. So for those reasons, if the court is inclined to believe this gentleman who's a convicted liar for purposes of exam and bind the matter over, I ask that you reduce the charge to second degree murder. Thank you.
Mr. Butler.
Your Honor, I think the court has to take into account the testimony that it has in front of it. Obviously, I understand defense counsel wants to argue things that his client told him, but that's not before the court. What we do have is the facts as the court heard it, and I do think that this is a first degree murder case. We have premeditation. We have an argument that lasts for 5 to 10 minutes. It's broken up. While they're talking to each other, guns are put away. Mr. Houston put his gun back in his pocket, by Mr. Abraham Houston. And then as Mr. Javon Houston is getting everybody out of the house, saying everybody has to leave, it's the victim who leaves the house. He's out on the lawn. And the defendant at that time certainly had ample time to premeditate the murder. The victim just ate his girlfriend's hot dog. They had an argument. He pushes past everybody. Now, it would be different if immediately after Mr. Javon Houston put his gun away, the defendant shot. But the fact that the victim is out on the grass and the defendant is pushing past everybody to get to that front porch and then immediately shoots him certainly shows premeditation, or at least by probable cause. So I am asking the court bind over on counts 1 and 2.
All right, so I'll say this, that the witness that was called was not one of the best witnesses the court's ever seen. In that, there may be a number of reasons for that, because all of these people are related. These are cousins, and I'm sure this wasn't ideal for him to come forth and testify about one cousin shooting and killing another cousin. I'm sure that that's caused quite a rift in the family. Because you guys are family. I don't understand what's going on. I don't see so much as a problem with identification, although Mr. Clemens brings up some very valid points in that the number of times in reporting the incident, the missing video player that would have captured presumably some part of this homicide, maybe, I don't know, but that is missing. He doesn't know where it's at. There's approximately 15 people in this house. He represents one person who's a cousin to both the defendant and the victim. Also, the victim was allegedly armed at some point in time. The gun is gone too. So the gun is gone, video recorder is gone, and a witness who doesn't give up the story of the defendant being the shooter until police indicate that he may be involved in this to some degree. Doesn't necessarily mean that he's lying, but for the sake of the people's case, we probably better not rely on this witness alone for the trial. That's not for me to decide. I have to decide whether or not to present a case for a probable cause for a person to be murdered premeditated. I have a claiming witness that's been shot 8 times. Six of these gunshot wounds. 5 of these gunshot wounds were to the back portion of his right arm and right wrist. One could argue that he was either trying to turn because he saw it coming, lifted up his arm, trying to shield himself from the gunshots. The testimony that the incident happened over a hot dog, as ridiculous as it sounds, this court has heard ridiculous and continues to hear ridiculous day after day. Like I said, I've heard people getting shot with one slice of Little Caesar's pizza. Shot and killed over one slice of Little Caesar's pizza. Someone stepping on some gym shoes, getting killed. So fact that this was supposedly over a hot dog. As sad as it sounds, this court is not at all surprised. It's stupid, it's ridiculous. But the witness also testified that there was a period of time before the initial confrontation that he separated two cousins. And the defendant then allegedly rushes past others and shoots the complaining witness while he stands on the grass in front of the home. Question is that enough time for the defendant to reflect on his actions before he takes and fires 8 shots? I would submit to you that there's an argument that it could very well be first degree murder premeditated. There's an argument that can be made that they were still within the heat of that argument. And this is a second degree murder because of intent to kill in the heat of the moment, so to speak. But this court is to decide whether or not the people have presented enough evidence on each and every element of the crime is charged, and submit to me that they have. As such, the court is satisfied the people with their verdict probable cause as relates to the charges contained in the complaint. The court finds those charges were committed in the city of Detroit. The court finds probable cause in the district of the committee. And it will be found located in Wayne County, Third Circuit Court of Criminal Division, federal proceedings. Is a right on the information date and time of April 16th, 2024, 9 o'clock.
Doesn't it address one other matter?
Yes.
So the court, of course, did not opine or find that Mr. Houston's testimony was so critical that the matter should be dismissed. But the court did specifically state that it wouldn't be wise for the people to rely on Mr. Houston's version of the event solely. That's all they had. That's all they had. There's no other statement. There's no other witness that's come forward with any testimony. So you're talking about an individual that's going to be relied upon, that's going to testify in that manner, for which there's little to no corroborating evidence for his circumstances. Even if the court looks at the medical examiner's report, and I asked him about Mr. Houston's body positioning at the time that he was shot, can't offer any details. I submit that to you, that's because he's lying to you. And if he was to say, if the court looks at the ME report, Mr. Houston was positioned in the manner that the court described, or Mr. Houston was laying on the ground, and that's why he shot in the back of the head, or that's why he shot in the head. If we were to hear testimony from the medical examiner, I was originally hoping that he would be, so we could talk about the trajectory. It would give us corroborating details for what Mr. Houston does or doesn't say. Mr. Houston didn't see any of it. He's not a good witness. And for my client to be remanded based upon his word alone, I think is unacceptable. What we do know is that the deceased in this particular case has a violent criminal history, all of which will come into play at trial. What we do know is that he was armed with a weapon when he shouldn't have been. He'd just gotten out of jail and was on probation at the time. The jury will hear all of these things. Coupled with the missing evidence, coupled with the fact that they're going to be asked to rely upon a liar in order to convict the defendant. There's no trier effect that would determine that the likelihood of conviction for Mr. Medley is high, and he should be admitted to bail, Judge. I'm asking for a bond to be set at $100,000 cash assured, based upon the fact that as I review the investigative report, there's no other witness. And if I'm wrong, Mr. Vela will certainly correct me. But that's what I have now from an evidence perspective. This is a month after the shoot.
Your Honor, we do believe that this defendant poses a significant danger to the community. Now, obviously, regarding his use of weapons in the past, I understand he was acquitted of murder in 2021, but he has had incidents where he's been involved in shootings where individuals have died in the past recent years.
I gotta object to that. If he's found not guilty, how can you say that?
Being found not guilty is different than him being involved in. I'm not saying that he did that murder because he was found not guilty, but he's involved. And then here we have 2 years later, he's involved in this shooting, which also resulted in the death of the victim. In this particular case, the police are trying to get more information. They are working on interviewing more witnesses. They tried to interview the defendant's girlfriend, who claimed the Fifth Amendment privilege and refused to provide any information. This is an ongoing investigation. Obviously, at trial, there's going to be other things that are going to come forward, such as the cell phone records that put the defendant at the scene. There's going to be, we're trying to find DNA. This just happened, less than 2 months ago. So this is an ongoing investigation, but we do believe this defendant poses a significant danger to the community. We would ask for no bond.
Judge, he doesn't touch on the issue at all. Remand is appropriate pursuant to People versus Reginald Davis, who I might add was my client, was a violent have-for, featured on Detroit's Most Wanted, charged with first-degree murder. Bail was assessed because the likelihood of conviction is low, unless the finding is that the likelihood of conviction is high, the defendant shall be admitted to bail. That's what the published case from the Court of Appeals on the issue says. Shall be.
Unless that person poses a danger to the community.
No, that's not what the court opined. Because then how would Mr. Davis be able to be out on bond? Judge, he was a violent have-for charged with first-degree murder. The standard from People versus Reginald Davis, and perhaps I need to disseminate this more because I get very agitated when my colleagues don't argue this. It's a published case. It came out in 2021. The defendant was determined to be admitted to bail because the likelihood of conviction was not high. Mr. Vela doesn't even address the likelihood of conviction. Instead, he just highlights the fact that my client's been charged in the past, but he has, unlike the deceased in this particular case, he has no criminal history, no convictions, none. Now, they may say, well, he has a hiding conviction. He has no criminal record. He's able to legally possess a firearm. The deceased is not. And if we make the case that the deceased in this particular case initiated the shooting, there's evidence to support that too. There's all kinds of defensive theories, Your Honor.
Is that Reginald Lamar Davis?
Yes.
And Your Honor, I do believe that case does hold that you have to take into account the likelihood of conviction. It doesn't specifically say it has to be, extremely strong. The court has to consider the likelihood of conviction along with danger to the community. I do believe, and I was trying to address this by the fact that you have other evidence such as cell phone data that puts the defendant there. Obviously, we are certainly working on more, but based on this witness's testimony, this defendant being placed at the scene by his own phone data, obviously the shooting, the way that it occurred, the amount, and I know the court said 8. I'm not sure if it was 8 or 9 shots that the victim sustained. I believe there is a good likelihood of conviction in this case.
No response to it.
Give me a second. Wrong decision. Sorry.
It's okay.
Mr. Clemens, did you represent this defendant who is not guilty verdict as well?
Yes.
Oh, right. Okay. This thing is way too long for me to keep reading. I'm still only about halfway through.
The only thing I would just say is just the holding. If the court just looks at what we therefore.
I'm sorry.
Yes. If the court just looks at the holding, we therefore conclude that the statute must give way to the Constitution. Okay, and the defendant is entitled to have bail set by the court, except in certain circumstances, such as when the defendant is charged with murder and the proof of the defendant's guilt is evident or the presumption is great. And meaning it's a requirement. That's what the court said in a published case.
So they're quoting Constitution. Is it the statute that reads that bail may be denied in cases where there's a flight risk or the defendant presents to be a danger to the community?
Yes, so the reason why, just to give the court the history, originally when Mr. Davis was granted bail, the Court of Appeals immediately overturned this. I filed an application with the Supreme Court, and the Supreme Court ordered the Court of Appeals to determine which trumps, the statute or the Constitution. Hence this conclusion that the Constitution requires the assessment as to whether or not guilt is evident or the presumption is great. And the record is what it is, Judge. Now look, that may mean that I get an astronomically high bond, because I've had courts, when I filed this motion and filed this brief, say, okay, Mr. Clements, bail will be set at $2 million. And I'm dissatisfied with that, but I have to accept it. Now, I would say that $2 million for an individual like him is still tantamount to a remand, but nonetheless, Judge, I'm addressing the issue of remand
You can't have bad facts and still get a remand and just say, well, look at his history and he doesn't have any convictions on his record.
I'm not necessarily looking at his history as it is, I'm considering whether or not he poses a danger to the community.
Fair enough.
I know that you're a great attorney. And you've proven that time and time again, even in the last case where he was involved in some kind of shooting of some sort. I have no knowledge of any of that other than what you guys have just told. But it does give the court some pause as to whether or not this defendant presents a danger to the community, because lightning keeps striking in the same place. But he hasn't been convicted of anything. If this is all the proof that the people have, then they have a very weak case based on this witness. It's not a very good witness at all. The story doesn't necessarily jive. His demeanor, all of that. He was a horrible witness, if I may say so. Right. But this people versus Davis, if I'm to assess the likelihood of conviction here, I would say the likelihood of conviction is not great. And if the court is to consider that, and that outweighs whether or not he presents a danger to the community or a flight risk, then from my reading of this case, the defendant is entitled to a bond. I'm going to set a bond at $250,000 cash sure. GPS tele house arrest.
Thank you, Your Honor.
Thank you. Have a good day, Your Honor.
Thank you. I need a bond reduction, Mr. Clemens.
Yes.
Good job, Mr. King.
Thank you.
Yeah, I know this. Everybody keeps running.
It's like that in all the cases. Isn't just this.
Judge King, were you ever a defense attorney, or you all were in prosecution?
I started out doing defense work. And became prosecutor like 2 years later.
Okay.
I need to move over here.
I'll sit there. Give me your size.
That concludes the docket for today, folks. Hope to see you tomorrow, same bad station, same bad time. Have a good evening. Good day.